GEICO ordered to pay Missouri woman $5.2 million after she contracted STD in car. GEICO must pay $5.2 million to woman who got HPV from sex in man's insured car, court rules. Well, I'm sorry to tell you that the headlines are wrong. But the truth is even more interesting because it involves nuances and esoteric details of insurance law. Now, you may have heard that GEICO is on the hook for $5 million because a woman contracted HPV after she had sex with a man in his 2014 Hyundai Genesis that was insured by GEICO. And it is true that a thing happened, that a lawsuit was filed between the former couple. The man knew he apparently had throat cancer that was caused by HPV, but did not tell the woman that he had it. She took him to an arbitration and was awarded more than $5 million. As lawyer Ellie Mistal put it, that was probably an expensive 15 minutes for GEICO. Now, it occurs to me that I probably should have put a warning on this episode. If there are any kids watching, sex is when two people love each other and then wrestle in the back of a car. In this case, a 2014 Hyundai Genesis. And when those two people no longer love each other, they will sue each other for what happened in that car. Now, how does that implicate GEICO, you might ask? Well, the man's car was insured by GEICO. The encounter happened in 2017, and the woman filed an insurance claim, which GEICO denied. GEICO told the woman its auto insurance coverage didn't apply because the damages claimed did not arise out of the normal use of the vehicle, which I think we can all agree probably makes sense. And now, to understand this whole case, we have to take our first diversion into the nuances of insurance law. Because generally speaking, when you get an insurance policy, it provides insurance over, let's say an accident happening, an occurrence of some kind. But in addition, you'll often get what's called a duty to defend. In other words, if you are sued over something that might be covered by the policy, then the insurance company has to provide lawyers, or at least the funds for lawyers, to defend that case.
Send lawyers, guns, and money.
Now, when an insurance company refuses to defend its policyholder, it's considered basically the same as denying coverage outright, saying that the policy doesn't cover the accident that happened. So an insurance company that wrongfully refuses to defend its insured can be liable for the cost of the defense and any damages that arise from the breach of their duty to defend. Now, how do you know if a policy is going to apply to an accident or whether the insurance company has a duty to defend you? Well, you look to the four corners of the complaint in the lawsuit and you compare that to the policy itself. This is called the four corners rule, or sometimes the eight corners. You're comparing what's contained inside the lawsuit complaint to what's contained inside the policy. And if it's possible, if it's a remote possibility that this claim could be covered by the insurance policy, then the insurance company has to provide you with a defense. Now, if the allegations are untrue, then the insurance company won't have to pay a judgment because, well, they'll win. But you can't know that until the trial is over, which is why the insured needs someone to pay for their defense. And that's why there's often a duty to defend under certain policies. And that's why sometimes the defense costs are the whole ballgame. If the insurance company denies the defense, then the insured might be in a world of trouble. They have to defend against a lawsuit all on their own, and lawyers are expensive. Now, an old partner of mine used to say that the only thing an insurance policy gets you is the right to sue an insurance company. In other words, if they deny your defense or deny coverage, then you might have to sue the insurance company if you lose the initial case going forward. But that's why some plaintiffs' attorneys will actually specifically try to cast their allegations in a way that will invoke insurance coverage so that they make sure the insurance company is part of the litigation. They'll either add another claim or they will craft the story of what happened in a way that might fall under coverage of the insurance company, because the insurance companies tend to be the ones that have the big pockets. So now we come back to this particular case. In February of 2021, the woman sent GEICO a copy of a lawsuit that she was about to file against the insured, the guy that she had sex with in the car. She offered to settle the claim for $1 million. GEICO ignored the notice. Basically, GEICO decided that the claim wasn't covered and refused to defend. Basically, GEICO said, having sex in a car that we insure is not covered under the policy, so we're not going to provide coverage and we're not going to provide a defense to the guy whose car it was. And for the record, these people only use their initials in the lawsuit, which was probably an incredibly smart decision so that they don't go down in history for something that may or may not have happened in this particular suit. And for the record, MO is the injured party. She's the one that contracted HPV. MB is the man with the car who gave her HPV. So now we're in 2021. MB is going to defend this lawsuit on his own dime because GEICO has refused to provide a defense. So GEICO basically takes itself out of the picture, at which point the insured, MB, the guy with the car and the STI, enter into an arbitration agreement with MO in March of 2021, and they agree to settle their dispute through arbitration. Now, Missouri's insurance laws have some procedural quirks, and the relevant statute is section 537.065. That statute allows a claimant, like MO, to enter into a contract with the tortfeasor, here MB, the guy with the HPV, to settle their dispute in private arbitration, which would be much, much cheaper and much, much quicker than going to trial in state court. Now, you're allowed to enter into one of these agreements when the insurance company has refused to defend the insured or agrees to a defense under a reservation of rights, which I won't go into. Now, the parties enter arbitration with an agreement that the maximum payout that the arbitrator can give is whatever the insurance policy limits are, and generally that the plaintiff won't go after the defendant, the tortfeasor, and will just take the judgment and use it against the insurance company, which, as discussed, depends on whether the claim is covered or not. Effectively, the plaintiff is gambling that the claim is or should have been covered. And if they win in arbitration, they're going to take that award and say, you insurance company, you should have covered your insured, and therefore you can just pay me everything that was owed because we made this side agreement. So in other words, once you get an award in arbitration, either the insured sues the insurance company and turns that money over to the claimant, or the claimant, standing in the shoes of the insured, sues the insurance company saying that they wrongfully denied coverage or defense costs. That's called subrogation. Now, obviously, insurance companies hated all of this, and that's why this section has been amended twice, once in 2017 and once in 2021. And this is effectively exactly what happened here. They went to arbitration without GEICO, because GEICO said they didn't want to participate, they didn't think it was covered, and the claimant got an award of $5.2 million. And the arbitrator found, and yes, this is the actual language that the arbitrator had to find because law is interesting. The arbitrator found, quote, there was sexual activity in insured's automobile in November, December of 2017, which occurred in Jackson County, Missouri. 2, the sexual activity in insured's vehicle directly caused or directly contributed to MO to be infected with HPV. 3, insured knew or had been told his throat cancer was diagnosed as HPV positive. 4, insured should have disclosed his diagnosis to MO prior to their sexual activity that occurred, and he did not. And 5, insured was negligent and is liable for causing MO to contract HPV. The arbitrator found that the amount that would fairly and justly compensate plaintiff MO for all of her damages and injuries is $5.2 million, and entered an award in that amount in favor of plaintiff MO and against the defendant, the insured. So in the end, the arbitrator awarded her $5.2 million in damages, and so the headlines were sort of right that MO did get a judgment for $5.2 million against the guy that screwed her. Pun absolutely intended. But here, it just wasn't against GEICO. Yet. GEICO asserted that the plaintiff and defendant had conspired to jack up the damages award in the arbitration. MO's counsel says that this wasn't the situation in their case, that the liability and damages were determined on the merits, and the arbitration proceeding was not based on any admissions, and that it was fairly contested. There were arguments and witnesses going both ways. But after this arbitration award, the woman informed the insured that she would file an action in state court to confirm the damages award, which is what you do. When you get an arbitration award, you then basically confirm it in state court. Now, at this point, GEICO tried to intervene. They wanted a new trial because they didn't think the arbitration was fair. That motion was denied. But at the same time, in April of 2021, GEICO filed a separate suit in federal court in the District of Kansas, seeking a determination that it has no duty to defend or indemnify MB, the guy with HPV. So GEICO chose to fight its case on two fronts, one in the state court and one in federal court. And it's really the federal court case that's going to determine on the merits whether GEICO actually has to provide a defense or provide indemnity based on the contract language. We'll come back to that in a second. Now, in state court, GEICO argued that the judgment in the arbitration violated the company's due process rights, and the arbitration agreement was unenforceable. GEICO said it never had an opportunity to participate in discovery or to provide a meaningful defense. And by the time that they were aware of the judgment, they argued it was too late. And you can see some merit to this. They didn't get a chance to contest the facts in this more or less secret arbitration where the claimant and the insured might have colluded to drive up the award. And at the very least, the insured didn't care because by virtue of the agreement that he made, he wasn't on the hook for the damages. So he might not have colluded, but he also didn't care if there was this giant judgment because the plaintiff, MO, was just going to turn around and sue GEICO over it. Now, on the other hand, this arbitration and this award, it's not against GEICO. It's an award against MB, the HPV guy. If GEICO was right that the policy doesn't cover it, then they don't have to pay. And we'll talk about that in a second, whether the policy covers it. And if GEICO wanted to participate in this from the very beginning and they were worried that they would have to pay indemnity to MB or cover his defense costs, then they could have provided him a defense from the very beginning. That's the point of the duty to defend. And that's why state laws are often crafted in a way to incentivize insurance companies to provide a defense. Because you can't go back in time and provide a defense after the fact. So if you, the insurance company, are worried that you might have to cover the damages award, well, then provide a defense to the guy that you provided insurance and participate throughout the entire thing. As the Missouri court found, quote, GEICO's claim of constitutional deprivations presumes GEICO was denied the opportunity to defend its interests relating to MO's claims against insured, including the ability to challenge liability and damages. But GEICO did have the opportunity to participate and defend its interests, including the ability to challenge liability and damages by entering a defense of the insured. GEICO did not take advantage of this opportunity and instead denied coverage and refused to defend insured. Moreover, GEICO initiated a declaratory judgment action in federal court seeking a determination as to its obligations under the insurance policy. And that federal action provides yet another forum in which GEICO may defend its interests. And right, the federal court action. GEICO is currently suing in federal court for an order that says the policy doesn't cover the HPV transmission at all. And if they win, they won't have to pay anything, no part of the $5.2 million, because that judgment is only against MB. So the headlines were wrong. There has been no determination that GEICO is responsible for this $5.2 million award. For now. There's also no determination that GEICO wrongfully denied a defense to MB, but they might. Now, usually if someone files an insurance claim because they were injured in a car, it's because of an accident. That's one of the reasons that this seems like an unfair ruling. It puts insurance companies in a weird position of defending any and all claims, no matter how bonkers they might seem. But it's really a question of whether the insurance policy actually applies to this scenario. GEICO asserted that there's no way its policy can be interpreted to include this kind of negligence the woman sued over, the contracting an STI in a car. But to determine that, we have to look at the policy language. Generally, since insurance companies write these policies, the language is construed against them. Let me know if you've ever had a chance to write a custom insurance endorsement. Generally, the insurance company gives you what they give you. Which is why policies are often hundreds of pages long. They're trying to prevent any and all weird situation. So in this particular case, what does the policy say? Well, I had to do some digging, but I found the relevant language in GEICO's appellate brief. According to GEICO, the policy covers bodily injuries arising out of the ownership, operation, maintenance, or use of a motor vehicle. Now, you might notice that language is very broad. Does this type of injury arise out of the ownership of a car? Well, it seems like a lot of stuff arises out of the ownership. Does it qualify as use of the motor vehicle? Maybe. Is this a bodily injury? Maybe. Is it the type of bodily injury that's intended to be covered by an insurance policy? Who knows? But for the most part, you're just looking at the text and the meaning of the words that are in the policy itself, construed against the insurance company or in the light that is more favorable to the insured. So it's possible that GEICO might have to cover this, because if it's even possible that this language covers this situation, then GEICO was wrong to deny a defense to MB the insured, and they're gonna be on the hook for not only the attorney's fees, but also the award of damages itself. But we'll know soon. GEICO filed a lawsuit in federal court seeking a declaratory judgment that it is not responsible for this situation, and that is scheduled for trial in October. But even if GEICO loses, don't consider this a license to engage in unsafe sex, because you can bet that GEICO has already changed the policy language in all of its car policies to make sure that no future policies cover this situation in the future. But either way, it seems this is the new McDonald's hot coffee coffee case. People completely misunderstood what was happening in this particular case. But it is another example of using your car for weird things. But really, people, instead of using your car, since we're all working from home, you should upgrade your decoration. I recently upgraded my office with the help of today's sponsor, Displate. Displate sells high-quality metal art prints that couldn't be easier to install. I've been using Displate literally for years, even before they were a sponsor. Here, let me show you. Here's the one I've had for years. Easy to switch out. Boom. Adjust it. Looks good. Displate is great because you never have to deal with a cheap looking plastic frame or trying to make sure it's perfectly straight. Because you can hang them up using magnets, installation is a breeze, and you can easily swap them out with whatever you want. There are no nails and no holes. You can adjust it or replace it however you want. Displate has millions of designs ranging from movies, vintage posters, maps, art, music, nature, and the list goes on and on. I actually chose a bunch of inside legal jokes. Here's a patent application for a gavel. But whether you are a law nerd like me, you will find something that you love that you want to display every single day. And this month, Displate is offering a summer sale where if you purchase using the link below, you'll get 25% off 1 or 2 displates and a whopping 29% off 3 or more. And it's automatically applied to your cart at checkout. So click on the link in the description or the link that's on screen right now to automatically get a huge discount on whatever displate that you want and revamp your home or office. Plus, clicking on that link really helps out this channel. And while you're at it, click on this playlist over here with all of my other legal videos. So click on this link or I'll see you in court.